Good afternoon. I am Rebecca Kaus, and I'm here today representing Sen Manufacturing Company. Sen Manufacturing Company joins Tanith Cross in filing a motion to compel arbitration in this case. Plaintiff Mr. Jennings entered into an employment agreement voluntarily with Sen Manufacturing Company that contains an arbitral clause. It is clause number 9 within the employment agreement. It is labeled dispute resolution. Plaintiff seeks damages exceeding $75,000 in this case, and per the arbitral clause in the employment contract, it was agreed by both plaintiff and company that this complaint or complaints of this type would be settled with final and binding arbitration. Plaintiff signed and agreed to clause 9A that states any claim for money damages relating to my employment with the company, which involves the company and or its affiliates, shall be settled with final and binding arbitration under the national rules for the resolution of employment disputes administered by the American Arbitration Association. As you can see, clause 9 specifically states that any complaint of this type has been agreed by both parties to settle with final and binding arbitration. The motion that will come before you, Your Honor, really comes down to a matter of arbitrability. Is this an issue that is able to be settled through arbitration? The contract clearly calls for arbitration. You will also have to consider all of the factors that contribute to the question of arbitrability. The contract contains a promise by the parties to resolve money disputes through arbitration. This means that arbitration can be forced because the parties have promised to resolve their disputes this way. Also, you'll have to consider if any of the conditions placed on the arbitration within the contract have been met. If all of the conditions have not been met, then it would not be able to be arbitrated. However, you will see that they have all been met. The conditions listed within the agreement are that it is arbitrable unless the parties have agreed to the contrary, which we have not, that the law requires a form of settlement outside of arbitration, which it does not. And the final condition that we've mentioned is that it has to be a dispute or a claim that involves monetary compensation, which it does. So all conditions of the arbitration clause have been met, and this case is cleared to go forward with arbitration. The last question that you would have to answer is whether or not the issues contained within the complaint are public policy, public interest, social policy, or things along those lines. As you can see through the complaint, it is a straightforward employment issue that has no real public policy or social policy element to it that would need to be cited by a judge in a court. Therefore, the arbitral clause stands, and this case should be tried in arbitration. As well, arbitral clauses should be interpreted on the language, the plain language, the specific language within the agreement. And if there is any question by the plaintiff of the validity of the employment contract, the arbitral clause is to be read separate from the contract, and it is to be interpreted separate from the contract. So the validity of the overall encompassing employment contract has no bearing on the validity of the arbitral clause, which, as we've shown, has stand. And as this dispute does fulfill every contractual stipulation for arbitration, the plaintiff requires the burden of proof that the dispute is not within the scope of the agreement, and he will be hard-pressed to do so. Thank you.